Qualified immunity protects police from being sued. But does it go too far? Welcome back to America Uncovered. I'm Chris Chappell. One of the greatest things about America is that we can sue anybody, and I mean anybody. Two New Jersey men sued Subway because their foot-long subs are only 11 inches. A Texas man sued his date for texting during Guardians of the Galaxy Volume 2. A Nebraska state senator even sued God. God bless America, or we'll sue you. In America, you can also sue state or local government officials, including police officers, for violating your rights. That's according to the Civil Rights Act of 1871. But in a series of cases starting in 1967, the Supreme Court ruled that government officials, including police officers, had something called qualified immunity in civil lawsuits. That is, in certain circumstances, they couldn't be sued. Qualified immunity has been in the news recently because of the protests against police brutality. People argue that qualified immunity needs to be reformed or abolished because it unfairly keeps police officers from being held accountable for wrongdoing. The interesting thing is that qualified immunity is not based on a law or the U.S. Constitution. It's based on Supreme Court rulings, a prime example of what's called legislating from the bench, which sounds frankly uncomfortable. The Supreme Court says that qualified immunity balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. That sounds good, but in practice, qualified immunity has made it very difficult to sue police for things like excessive force, because police are protected from lawsuits unless you can show that they should have known they were breaking the law. So even in cases where the courts found that police officers did break the law, they could still avoid trial. Reuters did an investigation and found more than 36 of these cases in the last few years. So the main challenge for plaintiffs in excessive force cases is to show that police behavior violated a clearly established precedent. That means plaintiffs must find a previous case tried by the court where a police officer did something very similar and it was ruled unconstitutional or illegal, which is harder than it sounds because the Supreme Court has a very narrow definition of clearly established precedent. For example, in one case, a prison inmate sued a prison guard for pepper spraying him in the face, quote, for no reason at all. The appeals court granted qualified immunity because there was no clearly established case that showed a single use of pepper spray was excessive force. There were other cases where prison guards used multiple cans of pepper spray or tasers that were ruled excessive but weren't similar enough to be used as precedent. So this sounds like an interesting math problem. One taser is equal to 2 cans of pepper spray minus crying divided by uncontrollable shaking. In another case, a burglar sued a police officer for unleashing a police dog that bit him even though he had already had his hands up. The appeals court granted qualified immunity because there was no clearly established case that using a police dog while the suspect's hands were raised was unlawful. Here's another example. Police officers in Fresno, California were accused of stealing more than $225,000 of cash and rare coins while executing a search warrant on a suspected illegal gambling operation. Police deny they took the money. But the appeals court said either way, they couldn't be sued for allegedly stealing the money. That's because they were allowed to seize the money as part of their legally obtained warrant. That did not violate the Fourth Amendment. So, what if they personally stole the money after they legally seized it? Well, There aren't any previous cases to show whether that violates the Fourth Amendment, so they get qualified immunity. What a loophole. Fresno. So here's the issue. For a police officer, getting qualified immunity is not about whether they used excessive force or broke the law. It's about whether this kind of incident happened before, so courts can look to it as precedent. That's because in a 2009 ruling, the Supreme Court gave judges the option to simply ignore the question of whether a cop used excessive force and instead focus solely on whether the conduct was clearly established as unlawful. That means that in these civil lawsuits, judges don't have to rule on whether police officers' actions were unconstitutional at all. They can just rule on whether the officer should get qualified immunity, which makes the judges' lives much easier. But the problem is, if judges don't rule on whether police actions are unconstitutional, then these cases can't be used to create a precedent that will determine whether future cases are ruled unconstitutional. So then you're stuck in a catch-22, where if nothing ever gets ruled unconstitutional, then police will always get qualified immunity. In all the cases that I just talked about, the courts only ruled on qualified immunity. So that means we still don't know whether pepper spraying an inmate for no reason or unleashing a police dog on a surrendering suspect is excessive use of force. People who oppose qualified immunity argue it's making it harder and harder to hold police officers accountable due to everything we just talked about. But people who support qualified immunity say that police often have to make split-second decisions in risky situations, and qualified immunity gives them the latitude to make those decisions. For example, whether to release a police dog on a suspect who appears to be a threat. Supporters also say that qualified immunity protects police officers from frivolous lawsuits, which is important because the fear of these frivolous types of complaints and lawsuits could impact officers' ability to act and could cost lives. But police don't always get qualified immunity. A study of more than 1,000 federal court cases was published in the Yale Law Journal in 2017. It found that qualified immunity was denied in 32% of cases, but it was only granted in about 17% of cases. Other cases were settled or had rulings that didn't involve qualified immunity. So police officers are not getting qualified immunity all the time. But there's also the issue of whether qualified immunity discourages people from filing civil lawsuits against police in the first place. There's no way to know how often that happens. So for folks who think qualified immunity is a huge problem, what can be done about it? Well, for one, the Supreme Court could just change their minds. Every year, cases are submitted to the Supreme Court that involve issues of qualified immunity. They could use a judgment on a new case to change how qualified immunity is used. One of them this year was actually the one where police officers were accused of stealing all that money. But the Supreme Court decided not to hear that one. Maybe they thought it was just too stupid to deal with. Fresno. But groups including the Libertarian Cato Institute, the Conservative Americans for Prosperity, and the NAACP Legal Defense and Educational Fund are urging the Supreme Court to revisit qualified immunity. Libertarians, conservatives, and liberals, together at last. Despite that urging, the Supreme Court has decided not to hear cases on qualified immunity in their next session, even though some of the Supreme Court justices really don't like qualified immunity, like liberal Justice Sonia Sotomayor and conservative Justice Clarence Thomas, who agree on the issue but for very different reasons. But even if the Supreme Court won't revisit qualified immunity for now, Congress could still pass a bill to get rid of it. That way it would actually be spelled out in a law and wouldn't have to be legislation from the bench. The Democrats had put ending qualified immunity in their police reform bill that passed the House of Representatives last month. But like we said in our previous episode, that's not going to make it through the Senate. There's also a separate Ending Qualified Immunity Act, which was introduced in the House by Michigan Congressman Justin Amash, a libertarian. And that is how I found out there's an actual libertarian in Congress. Wow. and I thought the highest-ranking libertarian in government was Ron Swanson. The bill currently has tripartisan support in the House, but it's unclear whether that bill will make it through Congress or whether Trump would sign it into law. But even if qualified immunity is ended, some people think that it won't really change police behavior. Because if a civil lawsuit against a police officer wins damages, the officer doesn't usually pay. One study found that local governments paid more than 99% of the time. But because qualified immunity can be a shield for police brutality, or because it's an example of legislating from the bench, many people still think it needs to go. The good news is, even if Americans can't sue police officers, they can still sue God. So what do you think about qualified immunity? Let me know in the comments below. And please support America Uncovered by visiting patreon.com/AmericaUncovered and contributing $1 or more per episode. YouTube demonetizes us all the time, so we really need your support. Once again, I'm Chris Chappell. Thanks for watching America Uncovered.